Welcome everyone to our seminar on the post-COVID workplace. And just to say, we're on Zoom at the moment. If any of you have any questions for us arising out of what we've spoken on, then please do put those questions in the chat function. And if we have time at the end, we'll try and answer a couple of your questions. Now, this post-COVID workplace is uncharted territory. None of us really know what it's going to look like and what sorts of liabilities might arise that didn't before. So what Kate and I have attempted to do is identify the most likely issues that are going to come up in the workplace and help you to discern whether those are issues on health and safety, whether those are issues arising out of general common law duties, whether they are issues arising out of employment law obligations, or whether they're a combination of all three. So what are the types of considerations that you need to have in the post-COVID workplace? Well, physical health and safety is front and centre. The government has said they're going to lift restrictions at some point this month, but that does not mean that the duty is reduced on the employer to ensure the physical safety, health and welfare of their employees in the workplace. And in particular, the elements that employers need to focus on are going to be things like adequate ventilation and preventing risks of infection, risks of spread of infection in the workplace. The other consideration is what I think is going to be a new category of disabled employee, and that's those individuals suffering the effects of long COVID, because we are now in a period where people will have been suffering those effects for either a year or over a year. And in my opinion, depending on the severity of the symptoms, they may well qualify as disabled under the Equality Act, and that brings with it its own duties on employers. Mental health needs to be looked at in a wholly different light in the workplace, and the concept of an employee of normal fortitude has changed. Lockdown has taken a toll, isolation has taken a toll, and you may well be facing a workforce with reduced mental resilience. And that translates into the workplace in this way, that pressures, deadlines and workloads that previously didn't cause the employee a problem may be more difficult for the employee to cope with because they are less resilient. And the other effects of long COVID are that they might make an individual more susceptible to suffering a psychiatric illness. And there are also what I like to call the peripheral policies, things like flexible working and childcare provision, which arise out of these post-COVID considerations. Now, the most relevant statutes and guidance, I think, for those issues are, as I've set out here. So in respect of risk assessments, and this is Regulation 3 of the Management of Health and Safety at Work regulations. And what's most important under those regulations is not the obligation to conduct a risk assessment, but the obligation to subject your risk assessments to ongoing review, particularly where you are aware of circumstances that might mean the risk assessment is no longer relevant or needs to be updated to take into account new considerations. I also think that under the workplace health, safety and welfare regulations, the duty to provide adequate ventilation is going to be front and centre of an employer's health and safety obligations. There is also the statutory obligation on employers to report workplace injuries to a health and safety executive, and that does include COVID. And what that means is that employers will have to have proper policies or protocols in place so that they can ensure that things are being adequately reported and adequately actioned. And finally, there's also available government guidance, which is constantly being updated. And whatever views you might have about how helpful or not, it's always a good idea to keep that under review. So let's dive straight into the physical work premises and the kind of considerations that employers now need to have. And this includes obligations around working space and cleanliness of the workplace, which wouldn't really have been at the forefront of our minds before the pandemic, or such considerations we would think are more applicable in a factory setting than they would be in an office setting. So I've set out there Regulation 6 of the workplace regulations, and this is the regulation that deals with the requirement for the employer to provide effective and suitable ventilation. ensuring a sufficient quantity of fresh or purified air. Now that goes hand in hand with the HSE's approved code of practice and guidance. And that guidance has a special legal status because if there is a health and safety prosecution against the employer and the employer has not followed that guidance, the employer will have to show that they have complied with the law in a different way. So following that guidance, whilst not compulsory, does mean that it's more likely an employer will be complying with its legal obligations if it does so. In other words, complying with those obligations is likely to reduce liability arising in the first place of an employer. What does the HSE guidance say? Well, I've just cherry-picked a few of the guidance notes for you. It really involves looking at the type of air that's circulating in the workplace. So if you've got enclosed spaces where there's stale or hot or humid air, you really need to consider what your obligation under Regulation 6 requires you to do as an employer. Now, air taken from outside, so fresh air from open windows and open doors, will generally provide sufficient ventilation, depending, of course, on the size of your workplace and how many windows there are, etc. But I also want you to note what the guidance notes say about mechanical ventilation systems, and in particular air conditioning units. Now, unfortunately, here in the Temple, we do not have the luxury of air conditioning, but I know a lot of you are far more fortunate and have air conditioning processes and systems in your offices. Lucky you. But the obligation of the employer is really fourfold. You need to make sure that your air conditioning system is effective to filter out impurities. You need to make sure it's regularly cleaned. You need to make sure that it's regularly maintained, and you need to make sure it's regularly tested. That's really the essence of your obligations under the guidance. The obligation to keep the workplace clean is even more important. And there is another obligation under Regulation 10, which refers to effectively workplace space for each employee. Now, even though the government is likely to remove social distancing requirements at some point, there is still a statutory obligation on an employer to provide sufficient workspace. And the guidance notes say that as a minimum, 11 cubic meters of workspace per person, that is the absolute minimum. And you need to look at occupied and unoccupied space in the workplace. So if you have a large workspace, but it's taken up with furniture and fittings, then that particular space will be deemed as occupied space for the purposes of measuring what space is available for your workers. And just to illustrate the point on ventilation, there was a county court claim about 2 weeks ago where a member of the Royal College of Nursing made a claim against her employer because she had to work in an enclosed working space with moist, humid air and inadequate ventilation, which caused her to be exposed to a particular type of mold that caused a particular type of respiratory condition. Unfortunately, it's a progressive condition that results in a reduced life expectancy. Now, this type of mold was very unique. This type of condition was very unique. But the whole legal issues for the court was the question of ventilation. And in that case, the employer did not follow the HSE's guidance. And what the judge said in respect of reasonable foresight of harm is that whilst injury from this particular type of mold or this particular type of condition might not have been foreseeable, it was reasonably foreseeable that this employee was at risk of a respiratory condition from inadequate ventilation systems. So in other words, how did the employer fail in that case? Well, in that case, there was no risk assessment, and that included no assessment of the effectiveness of the ventilation in the workplace. The air conditioning units hadn't been working properly, but there was ventilation coming from an open vent, which backed out onto some bins, and that's where the mold was coming from. So just having open air or fresh air sources of ventilation isn't enough. You've got to look at whether there are any risks in that area. If it's an area of waste disposal, for example, can you really say that that air is fresh and clean? So let's move on to long COVID. Now, those employment practitioners among you will be familiar with the definition of disability under the Equality Act. It's really about having a physical or mental impairment which causes substantial adverse effect on normal day-to-day activities that lasts or is likely to last for a year or more. And I think long COVID will fall under that definition. If you look at the symptoms of long COVID, it's a combination of physical and mental symptoms. So fatigue, difficulties with memory and concentration, but it can also render an individual employee more vulnerable to developing a psychiatric condition as a result of their work. And these features, these symptoms of fatigue, etc., are exactly the types of symptoms that the statutory code says would amount to impairments of normal day-to-day activities. So what that means is, as an employer, it's not just considering whether this employee falls under the definition of disability, but in respect of common law duties and reasonable foresight of harm, it might be argued that this particular person, it will be reasonable foreseeable that workplace pressures might cause them or make them more likely to develop a workplace condition, a psychiatric condition. And the other important thing to note about disability, when looking at disability under the Equality Act, the bar isn't particularly high. So the definition of substantial under the statutory code means more than minor or trivial. And the other thing to remember is that once an employee meets the definition of disability or prima facie meets the definition of disability, it's not really a question of whether they have a particular diagnosed condition. The focus of the inquiry is on the effects and symptoms of the condition, not its classification. And that's in contrast to looking at a claim in negligence for psychiatric injury, because as you well know, to have a cause of action, actionable damage, you have to have a clinically recognized, diagnosed psychiatric condition. You do not need that for the purpose of establishing a disability under the Equality Act. So the duty that is created is first and foremost the duty to make reasonable adjustments. And this is where doing a risk assessment is really helpful, because the risk assessment helps you identify who and how is at risk, to categorize the risk, and to implement measures to control, minimize, or eliminate that risk. You also need to be looking at your other peripheral policies, like I mentioned earlier, and consider whether you need to do an equality impact assessment if you haven't done so, or whether you need to revise your equality impact assessment to take into account new categories of disabled employees, for example. There is a knowledge defense to any disability discrimination claim. It's got to be established that the employer had actual or constructive knowledge. And the statutory code of practice gives quite extensive guidance as to what is expected of an employer. I've set it out there, but let me summarize it in this way. Your starting point when you're looking at knowledge is always going to be what information is available to the employer. What's the employee telling you about their symptoms? What can you see and observe? What do the sick notes tell you? What does occupational health tell you? Sometimes that information will be enough for you to decide that this employee will probably be considered disabled under the Equality Act. But if it doesn't, it might be that that information is sufficient to put you on notice that you should be asking further questions to discern whether this might be a disability under the Equality Act. So that's really the essence of it. And even where an employee doesn't formally disclose a disability or condition, if you have sufficient information as an employer to think they might be covered under the Equality Act, it is incumbent upon you to make the suitable inquiries. And that's where the constructive knowledge element comes in. But it's not incumbent on the employee to make every sort of inquiry where there's little or no basis to do so. And this is why I come back to what information does the employer have? Now, indirect discrimination, in essence, to those PI practitioners out there, is where an employer has a PCP, a provision, criterion, or practice, or a particular policy, it's a lot of Ps, that is applied equally to all employees, but has a disparate impact in that it causes a disadvantage to employees that share a particular characteristic, such as disability or gender. Okay, and it's important to remember, and this is particularly for those claimants who are considering an indirect discrimination claim, you have to make the causal link between the PCP and the disadvantage suffered. It's not enough to say, there is a PCP, I have a condition, the link is self-evident. You have to go further than that and show how the operation of that PCP causes you to have that disadvantage, and that disadvantage is linked to your disability. So do not forget the importance of causation. There is a statutory defence open to employers of objective justification, which means the operation of your policy is a proportionate means of achieving a legitimate aim. And the case of Hardy and Hanson's gives us guidance as to the sorts of factors that a tribunal will bear in mind when they're looking at whether the objective justification defence is made out. And in particular, they'll be looking at the operation of the workplace, the operation of its systems, the reasonable needs of the business, the economic needs of the business, and looking at the economic impact that restrictions would impose on the employer's freedom. So factors like the size and resources of the employer are going to be important, and other factors such as suffering an economic downturn during the pandemic, which has put the employer in a worse position economically, may also be relevant. So what are the sorts of health and safety requirements on employers now that we are going to have individuals coming back into the workplace en masse, even though it's probably not going to look like it did prior to the pandemic? Well, one thing that's a really good idea, and this is approved practice by the Health and Safety Executive, is giving questionnaires to staff to give them an idea of the sorts of individual circumstances, be it health-related or carer-related, etc., that might impact on their ability to travel to the office, their ability to be in the office, or their working hours. Your risk assessments, however effective they were pre-COVID, are going to need to be updated. Even if the outcome of that is that you don't change anything, you need to show that you have considered these specific factors that I've been talking about. And it's even more important that you keep your other related policies, so your other health and safety policies, your peripheral policies like flexible working, updated as a result of that. And the duty to keep reviewing them and updating them is more important than ever. In particular, as I was saying earlier, make sure you have a proper disease management protocol in place. And that's particularly important where there's a potential office outbreak. So if someone's exhibiting symptoms, who do they report them to? What's your policy about sending them home and sending the team home? Do you have mechanisms in place if somebody suddenly has to self-isolate or a team suddenly has to self-isolate? And do you need to, in those circumstances, impose special measures for those who might be clinically vulnerable or those who are living with the clinically vulnerable? And what goes hand in hand with that is training, because it's all very well having a comprehensive policy, but your employees need to know that it exists. They need to know what it says, and they need to know what to do and how to do it in circumstances where they need to implement policy. Another key factor is health surveillance. Why is health surveillance of employees generally so important? Well, the HSC has published its criteria for the circumstances in which it would launch an investigation against an employer. And in the case of stress at work, if it receives evidence that a number of staff are experiencing work-related stress, that is exactly the kind of situation that would prompt an HSC investigation. So what that means for employers is that you need to have an effective system in place of recording absences, recording the reasons for absences, but also reviewing that, not just reviewing in the context of an individual employee, but reviewing it in the context of the workplace and looking for things like trends. Is there an abnormally high level of absenteeism or stress-related conditions in a particular department? Is that symptomatic of an underlying issue? For example, is that symptomatic of perhaps relationship issues? Is there a manager who people feel are bullying them? Are there unreasonably high workload demands in a particular team? So you've got to look for trends. Okay, and also another good indicator are high rates of staff turnover. That might, and usually is, an indicator of an underlying problem. Now, this is something for claimants to bear in mind. If you are considering both a workplace claim for stress or considering reporting the matter to the HSE expects that you will have reported these workplace stress issues to the employer. And not just that, but that you have given the employer sufficient time to do something about it. Now, some of you may have heard of the concept of organisational justice. This is a new area that the HSE has identified as one of the risk factors in stress at work. And organisational justice really is about how employees perceive the operation of policies and processes and workplace outcomes and interactions. This is going to be particularly prevalent where you have disparity in your workforce. So where you have in your workforce a proportion of employees that are working more at home than they are in the office, what you don't want is for issues to arise where those employees feel that workplace opportunities, training, development, promotion, etc., are better if you're in the office than you're out of the office. You don't want them to feel that they're missing out. And if these are employees with disability concerns who are missing out, then the operation of those policies might be indirect discrimination. Now, when it comes to cases of individual bullying and harassment, the HSE doesn't usually investigate those unless it's an indicator of a more organisational-wide problem. Usually what they will do is signpost those concerns to ACAS. And if they get individual concerns about potential discrimination or breaches of the Equality Act, they usually signpost those to the Equality and Human Rights Commission. If there are issues around a breach of the Protection from Harassment Act or of physical assault or violence in the workplace, that will usually be signposted to the police. Now, I've talked quite a bit about risk assessments already in the context of general obligations. Remember that the risk assessment is the blueprint for action. In other words, it tells you what to do and how to do it, but it has to follow with action in order to be effective. To defeat liability, to defeat an accusation that you've potentially breached health and safety legislation, it is insufficient to simply have a risk assessment in place if you are not implementing measures as a result of it. And it may be that your risk assessments require revision or creation of special categories, or that certain individuals might require an individual risk assessment in certain circumstances. Now, you can have dynamic risk assessments in certain contexts. I've just given an example of a county court claim, and this was in respect of a physical injury, but the principle remains the same. Dynamic risk assessments are really for work or situations where it's simply impractical or unfeasible to have a whole raft of individual risk assessments. So what you do is you train the individual employee to be able to conduct a dynamic on-the-spot risk assessment to identify risks and to take action accordingly. And if the employer has a proper audit trail for those training records, and you can show that the training is adequate, it means that the employee is competent to identify risks because of the quality of the training, and the employee is able to take action, you may very well defeat liability, as happened in this Swallowfield case. So the elements of a good risk assessment now, post-COVID, they should be looking at ventilation. They should be looking at what to do in situations where staff feel well in order to avoid exposing other staff to the risk of infection. They should be looking at mental health generally and have in place a system to monitor the mental health of an employee before their condition deteriorates to the extent that they have an actual psychiatric condition, because that's when your liability will arise in negligence. And also, a good risk assessment will identify the categories of the most vulnerable employees. Now, in respect of home workers, because some people will continue to work at home for the majority of their time, even post the restrictions being lifted, is making sure you have proper supervision and monitoring of working hours, making sure that there's sufficient face-to-face contact with managers and with their teams so they don't feel isolated, because that helps you to pick up problems. And that also helps you as an employer to pick up the triggers or the signposts that something's wrong with this employee, such as changes of behaviour. There are also risks, of course, associated with the employee's home working. Remember that you don't have a statutory duty to ensure they have adequate ventilation at home, but if there are risks in respect of the work equipment, and I'll give you a very extreme example, if the work provided laptop suddenly explodes, you have to have an adequate system in place whereby home employees can report that type of accident, and it is properly recorded and monitored. And finally, I've just set out for you some examples that the HSE have given of approved practices for employers. In other words, if employers are doing this, they are doing it right. And if they are doing these things and implementing these measures, not only does that avoid potential claims, but it gives very good defences when claims are made. And the essence of what they approve is really employers taking a proactive approach, taking a collaborative approach, consulting trade unions, employee representatives, occupational health, HR, even mental health professionals, and a preventative approach. In other words, we are going to take the approach that prevents liability arising in the first place for work-related stress. Again, I've given you some of the sorts of practical measures that can be adopted by employers to implement that. But it's really all about collaboration, provision of information, training, and consultation. And on that note, I'm going to hand you over to the very capable hands of Kate.
Thank you, Rehana. I now want to shift your focus slightly to talk about what I think are two of the most important areas with increased potential for litigation after the pandemic. The areas I'm going to focus on are detriment claims arising out of health and safety issues and flexible working. So, first of all, detriment claims in the health and safety context. The pandemic has made issues of health and safety newly relevant to every single employee and employer in the UK. Under Section 44 of the Employment Rights Act 1996, an employee has the right not to be subjected to any detriment by any act or any failure to act by the employer which is done on one of 6 health and safety grounds. I'm going to take you through those 6 grounds briefly before discussing their significance in the post-COVID world. So, first of all, where an employee has been designated by the employer to carry out activities in connection with reducing risks to health and safety at work, the employer must not subject that employee to any detriment for doing anything in that role as safety officer. The second case under Section 44 is the same as the first, but it applies to worker-appointed safety representatives and members of a safety committee. The third category under Section 44 protects employees engaged in consultations about health and safety. It's unlawful for the employer to subject any employee to a detriment for participating in those consultations or for participating in the election of representatives. The fourth case has 2 elements to it. The first element is that of an employee who works at a place where there is no safety representative or safety committee. The second is the employee, excuse me, who works at a place where there is an official representative or committee, but where it's not reasonably practicable to raise the relevant health and safety issue through the representative or committee. In either of those situations, it's unlawful to subject the employee to a detriment on the ground that the employee raised his health and safety concerns with his employer, excuse me. The fifth case is the employee who believes himself to be in serious and imminent danger and who quits work for that reason. The employee's belief must be both genuine and reasonable. If he or she cannot reasonably avert the danger, then he or she is entitled to get out of harm's way. The employer must not subject the employee to any detriment for leaving the area of danger or for refusing to return whilst the danger lasted. Finally, the sixth case is that of the employee who, again in circumstances of serious and imminent danger, takes protective action. Instead of leaving work, as in the previous case, the employee tries to tackle the situation by taking steps to protect himself or herself or others. The employer must not subject the employee to any detriment for taking or proposing to take such protective steps, provided that the steps are appropriate in the circumstances. So that's a very brief run through of section 44. Section 100 of the Employment Rights Act 1996 grants the employee the same rights, but in respect of unfair dismissal. So an employee shall be regarded as automatically unfairly dismissed if the reason or the principal reason for the dismissal is one of those 6 grounds that I've just been through. There's no 2-year qualifying period for a claim under section 100, unlike a usual claim of unfair dismissal. Now, the 2 scenarios I want to come back to are those which I think are most likely to be relevant in the wake of the pandemic. And those are scenario 4, the concerned individual, and scenarios 5 and 6, which can be taken together. And that's evasive and protective action in the face of serious and imminent danger. Before I do so, I just want to touch on the meaning of detriment. Detriment's not defined in the statutes, but it's been held to mean some disadvantage. A comparison can be made, if necessary, with another individual. So, for instance, the tribunal might consider the employee who is, say, a health and safety representative alongside a fellow comparable employee who's not a health and safety representative. If the former is worse off in some way as a result of carrying out their designated functions, he or she may have then suffered a detriment. Detriment clearly includes any financial or economic disadvantage, such as paying the employee less or requiring him or her to work harder or longer for the money. But it could also be requiring the employee to work unsocial hours or a particularly unpleasant role. It could even be moving an employee to a different department or withdrawing non-contractual benefits, such as a company car or parking permits. So the concept of detriment is very widely drawn. I want to come back now to the case of the concerned individual who raises a health and safety issue at work and has the right not to be subjected to a detriment as a result. Where employers can particularly fall foul of this provision is when health and safety issues are not recognised and identified as such. One important example would be an employee's inability to cope with workload. If this issue is treated as a performance issue, and for instance, the employer places the employee on an improvement plan or withholds bonus payments, say, the employer might then be opening themselves up to a detriment claim on the basis that in fact what the employee was raising was a health and safety issue. So where it looks like the employee is raising a concern and the employer misidentifies that concern, once the employee establishes the link, it will be an unlawful detriment, or depending on the circumstances, could even be automatically unfair dismissal under section 100. The risk of misidentifying health and safety issues is likely to be increased where employees are working from home due to the reduced scrutiny and supervision of employees as a result. Crucially, what employers need to be doing to try and avert these potential consequences is to ensure that they have appointed a health and safety representative or committee. And that does 3 things. First of all, it gives a streamlined mechanism through which health and safety issues are raised with the employer. Rather than an employee complaining to one line manager or another line manager, instead, health and safety issues are managed through one channel. So everything's easier and more streamlined as a result. And additionally, when significant numbers of employees are working from home, a representative or a committee will help to overcome the problems that are faced by a fragmented workforce. Secondly, and this is linked to that, the appointment of the health and safety representative or committee stops concerns from slipping through the net altogether. And that could lead to a potential civil liability on the part of the employer, where the employee has identified a potential breach and brought it to the line manager's attention, thereby potentially establishing foresight, and the manager does nothing about it, liability may well be founded, as I'm sure you're all very aware. So a representative or a committee might protect the employer against personal injury claims as well. Thirdly, the appointment of a representative or committee could provide the employer with an important defence in detriment claims. If there was an official safety representative with whom it was reasonably practicable for the employee to raise the complaint, but the employee instead brought the complaint directly to the employer, they will not have brought themselves within the provisions of either section 44 or Section 100. And that was exemplified in one of the few cases on Section 44 and Section 100, which is Castano and London General Transport Services, which was in the EAT last year. There, the claimant, who was a bus driver, was dismissed for misconduct. He was employed for less than 2 years, so he couldn't claim for normal unfair dismissal. And instead, he claimed under Section 100 and Section 44, arguing that the real reason for his dismissal was that he had raised health and safety concerns with his employer. His claim under Section 44(1)(c), so that's as a concerned individual, failed in the tribunal on the grounds that there was a health and safety representative at the garage where he worked who he should have raised his concerns with, and it would have been reasonably practicable for him to have done so. The tribunal dismissed his rather creative contention that his place of work was actually his bus route, where that representative didn't operate. And the tribunal said instead that the claimant's place of work was clearly where his work was administered from, i.e. the garage, not in fact where he might be during the working day. The other area of detriment claims I want to talk about are the 5th and 6th categories under Sections 44 and 100, and that's circumstances of serious and imminent danger. In fact, whilst COVID and the various variants continue to pose a threat, it's these grounds which are likely to be quite relevant. The effects of subsections 44(1)(d) and E are that where an employee leaves work or takes steps to protect themselves in circumstances of serious and imminent danger, the employer effectively cannot do anything. Provided the employee can make out his or her case, the employer cannot, for instance, withhold pay or discipline the employee. Of course, each case will turn on its own facts, but as we see the gradual return to the workplace, employers might need to consider whether serious and imminent danger could be caused to employees by the enduring effects of the pandemic. And Rehana's touched on this, but for instance, requiring employees to work in close proximity to one another, or even potentially inviting non-vaccinated employees back into work. So where an employee reasonably thinks that they are in serious and imminent danger, for instance, as a result of a fellow employee displaying signs of coronavirus, once they've exhausted all reasonable steps to avert the danger by, let's say, requesting PPE, they will be entitled to leave work. Now, this is, of course, uncharted territory and there's no direct authority on point. We don't know how the court is going to react in these kinds of cases. What we can say, though, is that the important thing to do is to minimise the risk, however possible. Risk assessments, of course, are going to be essential, as it's going to be far easier for an employer to argue that the employee was not in circumstances of serious and imminent danger if the employer can point to a good and rigorous risk assessment. The second overarching topic that I want to speak about is the right to work flexibly during what we hope will be the very final stages of COVID, as well as after the pandemic has finally retreated. This is a hot topic in Parliament at the moment, as I'm sure you know. The Labour Party is pushing for employees to be given the right to work from home, and ministers have promised to consider an employment bill to upgrade workers' rights. In that context, I wanted to discuss the current law, as well as some of the traps that employers who refuse requests from employees to work flexibly might then fall into. Provided an employee meets certain qualifying criteria, he or she has the right to apply to his or her employer to work flexibly. In the language of the statute, the employee may apply for a change to his or her terms and conditions of employment if the change relates to the hours he or she is required to work, the times when he or she is required to work, and where between the home and place of business that he or she is required to work. For the purposes of this talk, I want to think particularly about the employee's intention to work from home, and that's of course for obvious reasons. Over the last 18 months, over 50% of the UK workforce worked from home, and it's unlikely that people are going to want to say farewell to those new working patterns altogether when and if the pandemic finally retreats. I think it's pretty likely once we all return to work, employers are going to see a real spate of requests from employees requesting to work increasingly from home. And that seems to be reflected in what the politicians are talking about. Under Section 80G of the Employment Rights Act, an employer must deal with an application by an employee to work flexibly in a reasonable manner. and shall only refuse the application if it considers that one of certain grounds applies. And those grounds include considerations of cost, ability to meet customer demand, organisation of work, recruitment, quality of work, and employee performance. So what do employers need to be aware of when dealing with applications from employees to work from home more permanently? In the first instance, where an application to work flexibly is refused by the employee may present a complaint to the tribunal. If the tribunal finds the complaint to be well-founded, it may make an order for reconsideration of the application and even an award of compensation. It will be far harder for employers to justify a refusal of an application to work, at least partly from home, in the future. The pandemic has unlocked flexibility in far more jobs than was previously thought. As we're all aware, many of the traditional objections to flexible working have been rendered slightly more irrelevant by whole companies working from home over the course of the last year. So I think employers will need to do more to show that they are behaving reasonably. For instance, there might need to be an explanation of why actually it was detrimental to the company for employees to work from home during the pandemic and why that model is not sustainable in the long term. What's more significant, however, is that the refusal of an application to work from home could well open the door to other claims as well. And that's particularly what employers need to be alive to, as they're inevitably faced with increased requests to work flexibly. In particular, where the burden of caring responsibilities continues to fall predominantly on mothers, an employer could well face a claim of indirect sex discrimination, where they've refused an application to work from home. Broadly speaking, that's what happened in Hardy and Hanson's, where the Court of Appeal was faced with an appeal by an employer against the finding that they'd indirectly discriminated against the claimant in refusing her request to job share upon her return from maternity leave. At first instance, the tribunal did not accept that the job that the claimant was to return to could not have been done by two job sharers or two part-time workers. The tribunal said that there were not certain functions which could not be split between two employees. Accordingly, the refusal to permit job share of a full-time job did amount to unlawful indirect discrimination, contrary to the statutory provisions of the time. The company's objections were found by the ET to have been overstated and exaggerated. The question for the Court of Appeal, which Rehana's touched upon, was whether the employer could show that their decision was objectively justifiable. And the Court of Appeal did accept that the wrong test had been applied, but ultimately the appeal was dismissed. The conclusion that the claimant had been indirectly discriminated against and unfairly dismissed was maintained. Now, Hardy and Hanson's is an old case. You might wonder why I've included it in a talk dealing with flexible working in 2021. The answer is that childcare, flexible working and indirect discrimination are not issues which have gone away in the intervening 16 years, and in fact may well come back to the fore in the context of requests to work flexibly. In fact, last week, the Employment Appeal Tribunal handed down its decision in the case of Dobson and North Cumbria Integrated NHS Foundation Trust. In fact, this was the inverse of the anticipated situation, in that the claimant, who was a community nurse, worked fixed days per week due to her childcare commitments, but she was then required to work flexibly, including at the weekends, after a review was brought in by the trust. The claimant had 3 children, and 2 of them were disabled, and she brought a claim for unfair dismissal, victimisation, and indirect discrimination after her employment was terminated due to her inability to work flexibly. At first instance, the tribunal dismissed all of the claimant's claims. The Employment Appeal Tribunal, however, allowed the appeal and remitted the case to the tribunal to be reheard. There were a number of grounds before the EAT, but the important one for the purposes of this talk was whether it was an error for the tribunal to find that no evidence was put before it to support the claim that the requirement for community nurses to work flexibly put women at a particular disadvantage compared to men. Was that, in fact, something that the tribunal should have taken judicial notice of? The EAT found that it was, and the tribunal had erred in law in failing to do so. The EAT found that the fact that women bear the greater burden of childcare responsibilities and that this can limit their ability to work certain hours is a matter in respect of which judicial notice has been taken without further inquiry on several occasions. The EAT called this the childcare disparity. Because the childcare disparity had been noted by courts for many years, it was a factor which the tribunal must take into account. In fact, it was so well established and had been so frequently referred to in previous cases that it didn't even have to be expressly pleaded for the tribunal to be able to take judicial notice. The EAT went on to find that the requirement for nurses to work flexibly was inherently more likely to produce a detrimental effect, which disproportionately affected women. So, Dobson has made it clear, beyond doubt, that in the eyes of the law at least, women bear the greater burden of childcare responsibilities. More broadly, however, the case underlines that compelling employees to work in a particular way may mean that employers fall foul of discrimination law. And you can see how other employees, not just women, might be able to make similar arguments. For instance, where a disabled employee makes an application to work flexibly, a refusal might amount to a failure to make reasonable adjustments. It is important to note just one final observation, however. Indirect discrimination can, of course, be justified on the grounds that it is a proportionate means of achieving a legitimate aim. In Dobson, the EAT found that the tribunal's consideration that the disadvantage would be justified anyway was in fact unsafe because it was based on an erroneous pool of employees. But that's not to say that the trust could never have succeeded on the justification point. And in fact, the matter was remitted to the tribunal for those arguments to be remade with reference to an appropriate pool of employees. So I hope that I have highlighted some of the different overlapping legal areas we need to be thinking about as we all, fingers crossed, return to the office in the coming months. We've tried to stress that no one knows what particular issues are going to arise in the workplace in the coming months. The only thing we do know is that it's always important to try and stay ahead of those issues. And we do that by anticipating risks by way of risk assessments or health and safety committees, or perhaps by giving greater consideration to where companies can afford for employees to work more flexibly and where they truly cannot. Thank you.
Thanks very much, Kate. And thanks to those of you that have given us some questions. I think we've got a little bit of time just to deal with a couple of those questions. So Shazad Ayub, thank you very much for your very diligent questions. Now, you have asked me to explain just briefly what's meant by deduced effects. And this is in the context of the definition of a disability. So for those of you that aren't familiar with deduced effects, what deduced effects means is that when a tribunal is looking at the question of whether an individual meets the definition of disability, they will look at the symptoms and the impairments without medication. So even if an employee is on medication to the extent that they have zero symptoms, the assessment of their disability is looking at the effects of the condition without medication. Now, of course, that will be relevant to the question of the employer's knowledge of disability. If the employer doesn't know that the employee is on medication, nor could it reasonably be expected to know it was on medication, the employee was on medication. But you've got to be a little bit more careful than that, because if, for example, you've got the employee saying, well, I'm on medication, but it controls my symptoms, that's exactly the type of situation where the tribunal would expect the employer to make further inquiries. Well, without being too intrusive, would you mind telling me what medication you're on, or how does that help your symptoms? So it will probably be more relevant to constructive knowledge than actual knowledge. And another question that we've received is an employer required to have knowledge of disability in respect of a particular individual in order for an indirect disability discrimination claim to succeed? The answer is, in short, no. If you have a claimant bringing a claim for indirect discrimination, that employee does not need to show that the employer had actual constructive knowledge of their particular disability. All they need to show for indirect discrimination is that they meet the definition of disability, that there is a provision, criterion, or practice in operation, that PCP puts them at a disadvantage when compared to non-disabled persons, and that they have actually suffered that disadvantage as a result of their disability. In other words, not having knowledge of an employee's particular disability won't be a defence to an indirect discrimination claim. And it's similar to having a claim for discrimination arising out of disability. For those of you who aren't familiar with those types of claims, that's where you have a particular symptom or effect arising from the disability, and the employee is claiming the sort of disadvantage or detriment in relation to that effect. And a probably simple example would be if you've got an employee who's disabled and has an unusually high level of sickness absences, and they're put through a sickness absence procedure and ultimately dismissed, they will be saying that's discriminatory, that's discrimination arising out of the disability. And the law has said that in those circumstances, the employer doesn't need to know that the employee has that particular disability. What the employee needs to show that there's something arising that they're relying on, in my example, the sickness absences, is something that arises out of the disability. And that link is not always a given, because you could have somebody who has a series of absences, only some of which are linked to their disability, some of which might be linked to completely different things. So that really is the short answer to what's actually a very interesting question. And I know that there was a question for Kate, and that question comes around the concept of serious and imminent danger. I do note that question came in before Kate gave a very good explanation about serious and imminent danger. But Kate, is there anything you wanted to add in addition to what you've said during the talk on that question?
Yes, so the question is an employee who refrains from coming into work as a result of believing to be in serious and imminent danger, are they still entitled to be paid their salary? Well, if we look at this through the prism of section 44, under subsections D and E, subsection D, the employee has a right in circumstances of serious and imminent danger not to be subjected to a detriment, provided they have a reasonable belief that there was a serious and imminent danger, and provided that they had taken reasonable steps to avert that danger. So in those circumstances, the detriment would be, of course, not receiving a salary, and that would be an unlawful detriment under section 44D, provided the employee could make out the reasonable belief in serious and imminent danger.
I think that takes us up to 4 o'clock. So thank you very much for tuning in, for being engaged, and for all of your questions. And I hope that was useful. I bid you good afternoon.
Thank you.